Boa noite a todos. Em nome da diretoria do IWIRC Brasil, composta por mim, Beatriz Faneca, diretora-presidente, Flávia Milardi, diretora vice-presidente, e Carolina Merizio, diretora de projetos, damos boas-vindas aos expositores e telespectadores. Hoje, traremos uma perspectiva dos impactos da pandemia do Covid-19 no universo de insolvência.
We will be talking about insolvency in Brazil, and we will be sharing solutions which have been implemented in the Brazilian legal, Canadian, Colombian, British, and North American system. I would like to make use of this opportunity to thank our panelists, Her Excellency Judge Maria da Penha Nobre Mauro, the judge of the 5th Business Court in Rio de Janeiro and a member of iWork Brazil, Karen Fellows, a Canadian Queen's Counsel in Canada, Vice Finance Director of iWork Global and member of the iWork Western Canada, Her Excellency Susana Ivegi, the Chief Insolvency Judge in Colombia and a member of iWork New York, Her Excellency Dr. Raquel Agnello, the Deputy Insolvency and Companies Court Judge in the UK and Queen's Counsel, member of iWork London. And finally, Her Excellency Laurel Isikoff, Chief Bankruptcy Judge for the Southern District of Florida in the United States of America, a member of iWork Florida. At the same time, I'd also like to thank our moderator, Dr. Danielle Carnio Costa, the judge of the First Bankruptcy Court for São Paulo, who will be the moderator of our debate. It's an honor and a great pleasure to have such a select group for a debate of such an up-to-date topic. Thank you very much. I'd like to give the floor to my colleague, Flavia. Good evening, everyone. Continuing our chair's words, I would like to thank the institutional support of iWork Global, IBAJUD, the Brazilian Association of Bankruptcy Trustees, and the Center of Women in Corporate Companies, and FONAGEM, the National Forum of Judges of Corporate Courts, IBGE, the Brazilian Institute of Corporate Law, the International Insolvency Institute, and ISOL International, and TMA Brazil, and TMA United States, as well as our sponsors, Secor Law, Capital Administradora Judicial, Brazil Expert, Rosman Penalva Souza Leão Franco, Attorneys at Law, Galdino Coelho, Attorneys at Law, Pinheiro Neto, Attorneys at Law, Faneca, Attorneys at Law, Takshuri Severino, Attorneys at Law and Bankruptcy Trustees, Carlos Magno Neri and Medeiros, Pinto Machado, Attorneys at Law, Confiança Administração Judicial, Leilão Judicial Eletrônico. And I would also like to thank all people joining iWork Brazil and strengthening women's participation at a national and international level in insolvency. We from the board are available to solve any questions about joining the Institute and to be very welcome to all of you. I would now like to give the floor to our director, Carolina Merizio. Hello, Flavia. Good evening, everyone. We have a great honor in chairing this event at such a sensitive moment of the global economy in which a sudden crisis has required from the legislative, judiciary, and administrative branches to make measures. The judicial branch has had a very important role in reestablishing the economic situation. And therefore, with this immediate need in order to face the crisis, in this virtual environment, receiving such well-prepared professionals from 5 different countries is a moment of great pleasure for iWork Brazil and a great opportunity to expand opportunities for following this event. In order to better explain the translation, because this is an event in 2 languages, the presentations made in English shall be translated into the global iWork account and translated simultaneously into Portuguese in the iWork Brazil YouTube account. So if you are watching in one language and would like to switch to the original language without translation, all you need to do is to click the link that is at the bottom in the description. So in both channels, whichever one that you are watching, you will have the link in how to access the other channel and be able to hear the original language. I would like to give the floor to Dr. Danielle, the moderator of this event, Wishing all of you a great debate.
Olá, boa noite a todos. Todos me ouvem bem?
Can everyone hear me well? Is this all working?
Muito bem. Sejam todos bem-vindos ao evento do iWork Brasil. Eu gostaria de, antes de mais nada, agradecer aos organizadores pelo convite para poder ser moderador de um evento tão importante como esse, ao lado de mulheres poderosas, muito representativas, cada qual no seu campo de trabalho. Então, para mim, é uma grande honra poder fazer parte de um evento como esse. Como se trata de um evento trabalhado em duas línguas, eu vou tentar falar apenas em português quando me refiro à audiência, quando fizer a minha apresentação, e quando me referir aos meus colegas, às minhas colegas palestrantes, vou conversar em inglês para facilitar a nossa comunicação. Então, vamos iniciar os nossos trabalhos, convidando para dividir a tela comigo a nossa queridíssima juíza Maria da Penha, juíza titular de Vara Empresarial do Rio de Janeiro. Eu gostaria de convidá-la para que, em 15 minutos, pudesse nos brindar com a sua participação. Judge Penha, um grande prazer estar aqui ao seu lado nessa noite, e Vossa Excelência tem 15 minutos para fazer a sua apresentação.
Good evening. Good evening. Thank you, everyone who is watching us today. For me, it's a great honor to participate in an international event of this importance, to be able to be a speaker amongst such important professionals. It's in fact a true honor, and I never in my life supposed that I would have this privilege. This is why I need to thank Dr. Faneca, Dr. Carolina Medizio, and Dr. Milardi for the generosity of the invitation which was made, for the choice of other names which I'm sure are much better than my name, to be able to be here and participate in this event. And I would like to greet my dear friend and colleague, Danielle Carnio, a professor who was a professor for most of us, a unanimous person, and I think this is something, it's a great honor to be here in a panel where you're the moderator. It is very important to be able to participate in this event, to be able to talk about the global perspective of facing the crisis. We have before us a pandemic, an epidemic of an infectious disease which has spread throughout the entire world. Something unforeseeable and something which was unpredictable, of having devastating effects in the entire global economy. The world has already overcome many events, many difficulties, has overcome plagues, other epidemics, wars, world wars, nuclear wars, but nothing as what we are seeing today, which we are watching with great astonishment. Not only because this is a world which is basically borderless, where few restrictions of a political nature or religious nature in some countries, basically anyone can travel anywhere into any country. And through many different means of communication, we also are able to enhance the commercial relations between the countries and the nations. This is something which is easy for us to do, And this is what we have seen for the speed of a propagation of COVID-19. But it's something which worries us because today our borders, they are not only physical, our borders and the borders which are used most often in the commercial world are electronic borders. It is where the majority of our relations, our commercial relations, our trade relations occur at a global level. That's why this pandemic has brought us the biggest world economies, the lack of knowledge, basically outdate regarding what is true chaos. This is true chaos. And our generation never thought this could happen. Financial economic crises, basically in all productive sectors, that have eliminated from the market, placing another in a situation of harm, such as, for example, in the field of hotels, entertainment, the industry of entertainment, which is definitely impacted with different areas of trade and industries which are in a very difficult situation, as well as many others. And some giants have become smalling, like Booking.com, that I think lost $699 million in the first quarter of 2020. Few have been saved from this chaos, very few. Many in difficulties, and some were able to grow, as strange as it may seem, as such as those that deal with electronic trade. And that's an example that I saw this week or last week of the Mercado Livre, which is similar to eBay in Brazil, which has become the biggest company in Latin America in market value. It has overcome giants. Of those of you located in South America, companies such as Vale do Rio Doce, a big mining company. Unemployment has devastated the biggest economic unities in the world. In Brazil, the unemployment that we have seen in March reached 12.9%, which represents over 12 million people who are unemployed in Brazil. Out of those 12 million, nearly 8 million are jobs which have disappeared with the pandemic. Therefore, we have all been surprised. Suddenly, we have seen a need to face situations which we couldn't imagine. We are having we have to have dispute resolution in ways that we never imagined. I've also seen very recently, what's very interesting in this context, the CEO of Booking.com, Vogel, if I'm not mistaken his name, who said the company has done many different training opportunities for the officers to face crisis situations, data breaches, natural disasters, cybernetic attacks. But for pandemics, they have never been trained. And they say, but of all of these events, the pandemic, COVID-19, was the worst of all. They have no clue how to handle it. No one does. It's not different for the judiciary branch, and it is not different for the Brazilian branch, or even for anyone of the other countries of the planet that I'm sure my colleagues will be able to talk about this much better than I can. We don't have laws to deal with what is happening. No one does. But the problems are here. We need to deal with them. Judges need to analyze these issues with much care because the users of the judicial system need a solution for this problem, which has also come to them in a surprise, and also because judges need to give decisions for the resolution of these issues in a manner following common sense. The country needs to generate wealth. The country needs to once again create jobs, taxes, to be able to overcome the basic needs of their population, and also to be able to grow, to once again have growth or to start seeing growth as a country. The judiciary has a crucial role in this regrowth because it has to act. It has to act to have the resolution of disputes that appear. And that's exactly what we're doing in Brazil. We're facing this situation in all the manners we can. We are solving problems when they appear, and I'm sure that there's still many others which will appear. The judiciary has been present to solve these disputes and at many opportunities creating alternatives or trying to create some alternatives to minimize those impacts. We in Brazil have of an administrative nature, which is the National Board of Justice, which has created some measures which are trying to standardize some procedures which might be present to serve the companies that are undergoing difficulties. That is something which is related to the companies undergoing difficulties. The CNJ has issued some has made recommendations in order to overcome these challenges. As there are no binding effects, it hasn't been accepted by most judges, but that's a measure for those who wish to adopt it. Não digita no meu não, digita no seu. We are on this path where we had a legislative initiative which has created a draft bill 1987 establishing certain measures for companies which are undergoing difficulties during the pandemic, more specifically for this time. This is a draft bill, an emergency draft bill, which is currently in the Senate. It has already been approved in the House of Representatives, and it's in the federal Senate, and it still hasn't been voted on. This remedy establishes several different manners, the suspension of enforcement for these companies undergoing difficulties, or the possibility of having an advanced negotiation of debt, the possibility of recovery, etc. So these are some measures which are an emergency, and this is just something for us to do during the moment of the pandemic. I think as this is not unanimous, this is also due to some criticisms this could generate some economic instability. And all measures adopted, all of them of a legislative nature or of a judiciary nature, and that's what I can talk about because that's where I am acting, that's where we have common sense. What is common sense? Obviously, judges need to understand and to establish what is the economic impact that this decision will generate at this time of the pandemic above all. Why? Because we have companies undergoing difficulties, companies that were undergoing a insolvency proceeding where they have had situation hindered even further by the economy. But on the other hand, we also have creditors. We have creditors who are also inserted in this chaotic scenario. These creditors also need to survive. These creditors also have bills to pay. They also have their obligations. In the Brazilian judiciary, we have received many requests for the changes in the judicial reorganization proceedings or the sale of some assets or some attempt to, I'm not going to say an advantage, but to receive some remedy in order to enhance the status of difficulties that the company that is receiving these restructuring process. But obviously, creditors also have the right to see the restructuring process go forward. Daniel has already turned on his camera, so I know my time is up. I'm coming towards the end. These are my final remarks. So we have seen very interesting cases where companies undergoing a reorganization plan wanted to change the plan for their benefit, but judges had to rule that the debtor can also not be affected. There were companies undergoing a reorganization in the hospital business, for example, that obviously had unexpected gains and in theory would have the capacity to better meet the payments of the claims which have already been established. But they could possibly improve that situation because they ended up benefiting from the pandemic. In other words, they ended up making more money during the pandemic than they would have in normal times. There are also situations in which we have to see if the reorganization process has to continue or if bankruptcy is the best solution in a situation where there's no possibility to overcome the problem. I have no doubt whatsoever that we will have a lot of claims before us and that the judiciary will have to analyze them. I have heard, I don't know if this is a fact, but I've heard that the 6229 law for the insolvency, for insolvencies and bankruptcies, that this would be voted on. And this law has some remedies which will be improving the insolvency in Brazil. One of these is exactly the relationship between the debtor and the creditors in terms of the recovery. I think mediation is a sign of the times. I have no doubt whatsoever that this is the method in which we will be able to hold the amount of requests that we will have in a near future discussing and to overcome the contracts because of the unbalance created by the COVID-19 pandemic. These are measures for us in the Brazilian judiciary, which is very welcome. Mediation is very welcome because in the year of 2019, we saw the report, the statistical report of the proceedings which were ongoing in Brazil on a database from 2019. These were nearly 80 million proceedings, more than 79 million. So there's no way for us to no longer think that mediation is a method which will support us to remove the burden from the judiciary at this moment, which we are facing problems brought by the pandemic. I'm sorry, I can't control the time. I can't do the two things at the same time. And luckily, I was the first to speak, because now you'll forget all the silly things I have said, thanks to the brilliant talks that you will have after mine. Thank you very much, everyone, for your attention. Thank you very much.
Muito obrigado, querida colega Maria da Penha.
My dear colleague, Maria da Penha.
Ouvir as suas palavras nos dá o alento e a certeza de que nós temos judiciário muito preocupado, que certamente está e estará empenhado em dar respostas adequadas e em tempo útil para os problemas que a pandemia nos traz. Em relação à votação do projeto de lei 6229, ele está sendo votado neste exato momento, está sendo discutido e votado neste exato momento no Congresso Nacional, na Câmara dos Deputados. And now I'm switching to English mode because I would like to invite Karen Fellows to share the screen with me. It's my pleasure being here. Thank you for being here as a panelist, and thank you for having me as a moderator in this iWork Brazil webinar. Karen works as Queen's Counsel QC in Canada, and now Karen, you have 15 minutes to make your presentation. Thank you very much. I think your mic is off.
I'm sorry, everyone. What a way to start. Thank you so much. And thank you again to the organizers and to iWork Brazil. Congratulations on putting on this event. I really do think this is a very special event due to the times we're in, and also to the makeup of the panel. We have women, an all-female panel, and very esteemed judges and practitioners from all over the world. And it's a distinct honor for me to be part of that group. I'd like to specifically send greetings from Canada. Of course, Canada, along with the rest of the world, has been very much impacted by the pandemic. And in many ways, life has changed completely since middle of March. I'm speaking to you today from an office in a tower in downtown Calgary, Alberta, Canada. And I walked through the office today, and I noticed that people still have their calendars on their desks, and they still say Friday, March 13th. And it's because most people have not gone back to work in the office towers in Canada. So our offices are like frozen in time. And in many ways, our lives have changed fundamentally. In order to describe the effect on Canada's bankruptcy system, I want to tell you a little bit about Canada and our legal system. Canada is, of course, a former Commonwealth, or it's a Commonwealth country and still has the Commonwealth legal system, except for the province of Quebec, which is a French-speaking province and has a civil legal system, civil code legal system. So in Canada, we do not have a specific bankruptcy court or bankruptcy judges. What we have is superior courts in each of our 10 provinces and 2 territories. And the judges in our superior courts sit as bankruptcy court judges when bankruptcy matters are brought forward in the superior courts. And what happened when the pandemic struck in the middle of March, struck Canada, was that many of our superior courts were caught unprepared and unawares. Many of our superior court systems had not been modernized. They still required in-person filings, paper copies of documents, and in-person hearings. So it was a big struggle for our court system to adapt to processing cases electronically because the courthouses themselves were closed. And most of the judges were basically not coming into work, and the lawyers were not coming into work either. So in many ways, this was a real wake-up call for the Canadian legal system of the need to modernize, because it became an access to justice issue. People weren't able to access the judicial system effectively. And of course, people who don't have access to computers or electronic means to access the courthouses as well were very much affected. So this was an opportunity, really, for people to start to rethink the old procedures and some think creatively about new ways to deliver access to justice and to make our legal system more effective for people in processing bankruptcy cases. Each province has its own public health directives as to when they can sort of reopen the facilities, and I'm very happy to report that Canada has now started to reopen its society, and our legal system is now coming back into a process where it will hear matters again. For a while there, the courts were only hearing matters that were deemed urgent, and the judges were conducting them however they could, usually over the telephone from their houses. But in many cases, bankruptcy matters are urgent. So most big, large commercial cases did find a way to get heard. In our major commercial center of Toronto, their court system had what they called a commercial list, with a bench of experienced bankruptcy judges, and they were much better able to adapt quickly to a modern process. In terms of Canada itself, many of our industries have been greatly affected, and we certainly saw a large wave of bankruptcies happen in some of our major industries. In Western Canada, where I am located, we saw a lot of restructurings and bankruptcies through our oil and gas and mining sectors. And then, of course, we're seeing more and more bankruptcies in the retail space. We think commercial real estate is going to be greatly affected as well. And then, of course, any industries relying on travel, hospitality, tourism, airlines, auto rentals, all of those industries have been greatly affected. And I'm sure that's true throughout most of the world. In terms of how our government is responding, the federal government initially put in place some emergency financing measures, both for struggling businesses and for individuals. So any individual who had lost their job was eligible for a $2,000 monthly stipend, and that process is continuing.
Karen, let me ask you a favor. We are having some problem of connection in one of our two channels, YouTube channel. So people from Brazil, I guess, they are not following us. So they asked me to talk to you, and then we can make a pause. So they try to solve this problem, this technological problem.
Of course.
Let's see. They are rebooting the system. Okay, we are back. Perfect. Sorry to interrupt you, Karen.
Not at all.
You can proceed, please.
Not at all. As I was saying, our federal government rushed to put some emergency economic support into our economy, and that included right down to the individual level. People were being sent $2,000 a month to cover their basic expenses if they had lost their jobs. But, we're now coming to for the foreseeable end of this government support, and we do anticipate a large wave of both large commercial insolvencies and probably personal insolvencies as well. And the question, of course, is, are we prepared for this wave? In Canada, bankruptcies are administered both through bankruptcy lawyers, but also through licensed trustees in bankruptcy who are licensed by a federal regulator called the Office of the Superintendent of Bankruptcy. And everyone is preparing for a very, very busy time ahead. The government has not yet put in legislation to amend our insolvency framework. However, they have put in sort of stopgap measures in terms of tolling certain limitation periods or extending certain rights, etc. And the courts of every province have also put in practice directions to try to assist people in dealing with moving their cases forward. But it is an opportunity, I really think, for people to start to rethink some of the old ways of doing things. And we're actually very excited that the courts are now seeing this as a priority to modernize and to embrace technology. And the governments are starting to invest the money necessary into our court system so that they can modernize and use some exciting new software programs that are really, we think, going to revolutionize the way both judges and lawyers work in Canada. So definitely, it's been a very sobering time for us here in Canada because it is a tragedy. But on the other hand, we think there are some real opportunities for innovation, and sometimes it takes a crisis to really force people to change the ways that they think and the ways that they do things.
Thank you, Karen. Can you hear me and see me now?
Yes, I can.
Would you like to conclude? You still have a few minutes.
No, I think I'm going to cede my time to the rest of the panelists. Thank you so much.
Thank you very much, Karen. We had some technical problems, but I think everybody was able to follow your presentation and understand how harsh the pandemic is for everybody, including Canada, and everybody was able to get the flavor of this overview on the Canadian insolvency system. Thank you very much for your presentation. And now I would like to go on and invite to share the screen with me Judge Susana Rivegui, who works as a bankruptcy judge in Colombia. Susana is not one bankruptcy judge in Colombia. Susana is the bankruptcy judge in Colombia. It's my pleasure being here with you, Judge Susana, and you have the floor to make your presentation for 15 minutes. Thank you.
Thank you. Thank you to IWORK for putting together this amazing event. I'm really honored to share this panel with this extraordinary woman and, of course, with Judge Carnio as moderator. As we know, we are facing an unprecedented, unforeseeable, and unparalleled situation. From Colombia, I have some bad news and some good news. So starting with the bad news, I think that Colombia is winning the record for the longest lockdown during the COVID-19 crisis. We have been in strict confinement for 4 months and 14 days now, since March 25. So every second, the business get closer to the inflection point where they will not probably be able to recover. So that's bad news. The good news is that the government has reacted early with regards to the bankruptcy system. So Judge Daniel was saying that I'm the judge in Colombia, and I'm going to explain that the structure of the bankruptcy courts in Colombia is very special, or is not as common as in other countries. So the superintendent of companies in Colombia is the bankruptcy court, but is part of the executive branch. It's part of the executive branch, but with judicial powers. So this is relevant to mention because the superintendent of companies as bankruptcy court is also part of the executive branch. So it is possible for the executive part of the work to promote adjustments to the bankruptcy regulation. And that is what happened in this case. So the good news is that we didn't have a system to make the virtual hearings, but it took us 10 days to meet with Microsoft and start using Microsoft Teams because we were using that in the superintendents as part of the tools for organizing our meetings in there. So we met with Microsoft, and we put together the way to operate with the virtual hearings using Microsoft Teams. So we developed a protocol that was published, so the users and the debtors and everyone coming to the court was familiar with how to use and what were the rules to participate in a hearing using these new tools. So it was new, but it has worked perfectly. And in fact, we haven't stopped making hearings or issuing rulings just for 10 days, and then we just continue working as usual. The other good news is that the government, the president, issued 2 decrees that has the force of law. So through these decrees, it was possible to amend or create special tools to face the crisis created by the COVID-19 pandemic. So first, I'm going to talk a little bit about Decree 560. This was the first decree. This decree created something new in Colombia. It created 2 prejudicial proceedings or out-of-court procedures. The bankruptcy court only intervenes to commence the proceeding, and after 3 months to confirm or not the reorganization plan. So this has the advantage that it will also create an automatic stay during those 3 months. And something new is that the debtors are not obliged to pay the administrative expenses for the 3 months of negotiations. This promotes alternative resolution mechanisms into bankruptcy proceedings because, as my other colleagues were saying, we foresee a big wave of new cases coming in. So the judge ultimately will confirm or reject the plan. And it also allows to have a partial reorganization, not involving all the creditors into the proceeding as it usually goes in a normal judicial proceeding. So we have 2 types of these proceedings: an emergency negotiation of reorganization plan before the bankruptcy courts, and the business rescue mediation that is done before arbitration, conciliation, and mediation centers. Also, this decree created the financing tools. We used to have rules saying that post-petition financing will have priority, but now with this deep financing sort of rule, post-petition financing or financing to the debtor in insolvency, the law recognizes the priority to the post-petition claims and creates a bidding process to allow the best possible scenario for the debtor and the creditors. So the bidding process is limited in time and must be approved by the court if the assets of the debtor are going to be encumbered in this financing. Also, this decree created a very special proceeding for a rescue, like a rescue in the border of the liquidation. So if a company is going to convert from a reorganization to a liquidation, in that very moment, any creditor may bid by filing an offer for a minimum value that must include the payment to first-class claims, that includes tax, labor or employee claims, pension-related claims, and administration expenses from the reorganization, and a protection for secured claims. For this procedure of rescue to apply, there must be no value for the shareholders. The shareholders must be deemed to be underwater. So if the rescue is successful, then the shareholders will be wiped out, and the creditors that bid will capitalize their shares and become the new owners of the company. The second measure, the second decree, is Decree 772. And the highlights of this decree is that it created a small business insolvency proceeding This was inspired by the discussions currently being held in the Group 5 of the United Nations Commission on Citral. And it brings two types of procedures, a simplified reorganization procedure and a simplified liquidation procedure. So with this small business procedure, the idea is to allow the small businesses to go through this insolvency situation with less complexity and less costs that are usually involved in a bankruptcy case. Also, this decree 772 included the incorporation of artificial intelligence tools to the bankruptcy proceedings. So again, foreseeing the amount or the growth in the amount of the cases that we will probably have to trial, we are planning to incorporate artificial intelligence tools for the review of the financial information of the filing. And in normal situations, the judge has to write every writ and every ruling during the proceeding. But with these tools that we have been developing from October last year, these tools will start to drafting some first versions of the decisions, so that will allow to use more efficiently the resources of the court. Also, this decrease brought some tax relief for the debtors facing insolvency, and we have been already receiving more cases that we used to have in average in previous years. So in comparison with last year, the increase have been like 50% in reorganizations last month. So the wave is getting higher. I think we can never be completely prepared because, as I said at the beginning, I think this still has unforeseeable effects, and the longer that we stay in a lockdown situation, the businesses are going to get closer to a very hard to recuperate situation. So for now, this is the situation in Colombia, Judge Daniel, and thank you very much.
Thank you, Susana. I appreciate a lot your presentation, because we can see that we are sharing the same problems here in Latin America, and I guess in the entire world. And it's good to know that we are trying to pass an amendment in our insolvency law. And I'll give you a presentation at the end, give you an overview about the Brazilian responses to the crisis. And one of those responses is we are trying to amend our law, and we are going in the same direction that you've gone in Colombia. Good to know that. So thank you very much. And now let's proceed to Judge Raquel Agnello, who works as a QC and a part-time bankruptcy judge in London, and who is fluent in Portuguese too. Yes, am I right, Judge Raquel? You have the floor for 15 minutes. Thank you very much.
Muito obrigada, Juiz Daniela. I'm going to make my presentation in English, although I speak Portuguese. But first of all, I don't want our wonderful Brazilian audience laughing, because I come from the Açores. So I speak Português com acento açoriano. And that might be a little bit tough for a lot of you. And secondly, I have lived for so many years in England that when I have to describe concepts in English law, it is a lot easier if I do it in English. So apologies for not doing my presentation in Portuguese. Now, thank you so much for inviting me to join this amazing panel, and thanks to IRIC Brazil. I should explain, as Judge Daniel said in the presentation, I am a part-time judge in insolvency, as well as being a barrister practicing in England. we have a system which is quite unique in the world, which allows someone like me, who remains in private practice, to sit as a judge. Unlike many countries, our judges in England are appointed from those who have been practicing barristers or solicitors, the two types of lawyers that we have. So sitting part-time as a deputy judge allows a barrister to see if being a judge is the job for them. Now, for me, it's given me the opportunity to see firsthand how difficult the job is and to see what annoys judges, so that when I am presenting a case, I know now what not to do in front of the judge. In case any of you ask, I still love being an advocate. I like being a barrister because I like winning cases. Now, that's a little bit about me. Let me take you through what's been going on in England with the COVID crisis and insolvency. Two things I want to deal with. We have brought in new legislation, but before then, it might be useful to know, how have we coped, this old-fashioned country, England, going remote? Well, since March, the courts, certainly some of the specialist courts, like the insolvency courts, have gone almost seamlessly into remote hearings. We are using an old-fashioned system of Skype for Business because that is what the judicial system had acquired for most of the judges. But from one day to the next, all cases went remote with different platforms. It's been amazing how many cases in insolvency we have been managing to deal with. And not just the full-time judges, but they've been using the part-time judges like me to make sure that we keep up to date with the cases. The Court of Appeal, our Supreme Court, the higher courts have done really well. Before you all think that this sounds amazing, it has been a disaster for the criminal courts, for the family courts, immigration issues, employment courts. And so the success stories are simply in limited areas. So I feel very lucky that we have been able to cope in insolvency, although the work has increased, and like most of the speakers, we think there is an increased bubble yet to come, which is why they are asking the deputies like myself to sit so much. Now, the second thing I want to talk to you about is, again, quite extraordinary for England to move so quickly. We have brought in a new Corporate Insolvency and Governance Act 2020. Most of the provisions of this act will disappear and become the Insolvency Act. This has been in force since June 2020. Part of it deals with temporary relief from possessions. So if you are a company and retail business, you will no longer be evicted for not paying rent. That will expire at the end of September. So most of the barristers like me and the solicitors are now very busy because all the companies realize that come the end of September, if the government doesn't extend this scheme, they will have to find new restructuring mechanisms because their rent will be due. The second point that they have made under these temporary relief is that they have prevented the courts from winding up companies, which means placing the company into a compulsory liquidation. That again is due to expire at the end of September. We have to wait and see if it is extended. Do I think these temporary provisions are going to save companies, or do I think that they are just putting off the inevitable? I think they are probably giving some companies some breathing space, but for the majority of them, I'm sorry to say, they need to find other ways to deal with it if they can. There has also been a change to actions which can be brought against directors to encourage, I suppose, directors to stay on top of their companies. There has been a suspension of our wrongful trading provisions. Now, for most of the lawyers like myself, this is a little bit of a political reform, temporary suspension, because actually in the last 10 years, there have been almost no successful actions for wrongful trading. We have actions for fraud against directors, actions against directors for breach of their duties to creditors. All of these stay in place. It's just the wrongful trading which goes. So it looks to us like it's a little political, but it may make directors feel more comfortable with trying to rescue the companies and staying there. We've also done numerous changes to corporate provisions dealing with remote meetings, notification, voting, resolutions. I think a lot of us are amazed at how quickly this act became law and how quickly it adapts so that we can have not just remote virtual court hearings, but meetings and everything to do with companies. But what is perhaps the most interesting part of this new insolvency legislation is the permanent changes it has brought in since the end of June to our insolvency. Now, those of you following English politics will know that since 2016, everything which comes out of England has been Brexit. What was the deal? No deal? How was insolvency going to deal with all of this? So for us insolvency lawyers, it's very exciting to see that this new act actually creates new regimes which have nothing to do with Brexit and have to do with regimes which have been in consultations for many years in England, but not brought into law through lack of time because of Brexit and other matters. So we now have two new regimes. One of them is a moratorium regime, which is an out-of-court procedure, which, for those of you familiar with the US system, it will be similar to the debtor in possession. And the other regime we've brought in is a recovery plans with a cross-class cram-down for dissenting creditors. Now, some of you may think it is amazing that England has not had these two types of regimes before. It's like that. We've now brought them in. So COVID-19 has perhaps helped, in another way, a reform of our insolvency laws, which were needed. Now, in respect of the moratorium, just briefly, it is a stay on certain creditors' actions. There is no need now to go into our administration. The directors remain in control, but there is a monitor appointed. This is a major innovation for English restructuring. There has always been resistance to allowing directors to remain in charge. Now, the monitor has to consider whether the company is insolvent, unable to pay its debts, and whether the moratorium will result in the rescue of the company as a going concern. Interesting points is that this is a regime available to overseas companies, just like the English scheme of arrangement is available to overseas companies that have a sufficient connection with the English jurisdiction. The same rules will apply for the moratorium. That means it could be interesting. You need to be very careful with whether you're an eligible company. And a lot of companies which have issued bonds or part of a facility guaranteeing even loan notes may find that they're not eligible by reason of it being a capital market arrangement. Has there been a rush since June for companies to rush in and enter the moratorium? Well, to date, I'm told no. It's an out-of-court procedure. You file the documents and then you are in a moratorium. And it seems like the rumor is that many of the monitors who are insolvency practitioners have not been very keen to put their names into moratoriums. It's new. They're concerned about it. They prefer to use the old regimes. And of course, it's the monitor that has to certify that it's an eligible company. Will these increase? You get 20 business days stay, which can then be extended. Will they increase? We have to wait and see. I think it makes people nervous that it's out of court, which means there isn't a court supervising it. Now, just time to talk about recovery plans and the cross-class cram-down that comes in by Part 26A. This has already been quite popular. Obviously, a lot of businesses have been waiting for this. And this is a court-monitored procedure. So it's the court which sanctions, and it gives people more comfort in knowing that the court is going to sanction it, and therefore it's not going to be challenged, or it will be challenged at the time. Now, these provisions came in very quickly, really quickly. The time for debate in our Houses of Parliament were curtailed. They are already being questioned. There are gaps. There are provisions which need to already be drafted in. And so we have this kind of living, breathing, new reform, substantial reform, which has not spent a lot of time being discussed and amended. It's just been brought into existence. So in one way, that's more work for the judges and for the lawyers. In the other way, it creates this uncertainty. Now, do I think that this new act is going to help the UK get through COVID? No, I think that it gives us more flexibility, but I don't think it makes the UK economy any better or worse off. Like a lot of countries, there has been a furlough scheme where the government is picking up the bill for certain jobs. But despite all of that, every day when you pick up the news, there are more and more redundancies. So the world is completely changing. What does this new insolvency regime do? I think it gives more flexibility, which may be important. Will the courts go back to as they are before? No. The chief judge has already made a long talk to tell all of us that we are not going back to as we were before. And the big dilemma for a lot of the barristers is, those of you who know, we wear wigs and gowns. So when you are doing a remote hearing, do you put on your wig and gown, or do you sit there with just a suit? The answer is no wigs and gowns. So maybe that's another way to modernize the UK system, by making it go remote and getting rid of these matters. Judge Danielle, I think I'm through my 15 minutes.
Thank you, Judge Agnello. It was very, very interesting to note that you have just created through this new legislation, the Corporate Insolvency and Governance Act, a new pre-insolvency tool, the moratorium. And we are just now trying to create in Brazil a very, very similar tool, trying to deal with the insolvency in an earlier stage before it becomes a judicial reorganization, which is very heavy and complex. And let's see how it works in Brazil. I think the experience you are already having in UK will be very useful for us. So we try to learn from your experience before make decisions here in Brazil. So thank you very much for your presentation. Thank you. And now I would like to invite Judge Laurel Isakoff, who sits as a bankruptcy judge in Miami. Judge Isakoff is for sure one of the most famous U.S. judge in Brazil, because most of the Brazilian cases with transnational connections are in Miami or in New York. So here in Brazil, at least the São Paulo judges and Rio de Janeiro judges, we are very used to hear from Judge Isakoff. So it's an honor for me to be here with you, sharing this screen. And Judge Isakoff, you have the floor for 15 minutes to make your presentation. Thank you very much.
Thank you so very much, and for your kind words. I am learning a lot more about Brazilian insolvency law sitting in Miami than I ever thought that I would. I want to thank iWork Brazil for the opportunity to speak to everyone and for the honor of appearing with these incredible women and with Judge Carnio. It is an opportunity in an unusual world in which we find ourselves. I speak in a unique perspective to you all, because in addition to being the chief judge of the Southern District of Florida, I also serve this year as president of the National Conference of Bankruptcy Judges, which is a voluntary organization with over 350 members, active and retired bankruptcy judges. I also serve on a committee of the federal judiciary that oversees the administration of the bankruptcy system. So in sum, I've squeezed in a little work with all my COVID-related work during the last 5 months. Our world really changed in the United States on March 9th. Why is that a significant date? Because that is the date that the National Basketball Association canceled all professional basketball games. And it was after that that there was this snowball effect for cancellations of all different kinds of events, including the shutting down of the physical access to courts. I will speak primarily about my experience in the Southern District of Florida, because there are 90 bankruptcy courts, or actually 90 districts in the United States, in the 50 states. And of course, COVID has hit the different states differently. And so the reactions of the courts, the bankruptcy courts, have been different depending on the circumstances, but in general have been consistent, because we all speak to each other electronically almost on a weekly basis, communicating and sharing the experiences that we have had to try to maximize the access to courts during this crisis. I will tell you that in the Southern District of Florida, which stretches from Key West all the way to far north of Palm Beach County, we closed on March 16th, but we have never closed. Similar to what happened in England, the bankruptcy courts were already allowing remote working by our employees, not on a regular basis, but they were working remotely. The courts already allowed telephonic appearances in many cases. And so it was a seamless transition for us to go remote. We did not at that time have video capabilities. And so our court, as well as others around the country, started looking at different options available to us. My court ultimately decided, and my court has 7 judges, well, until last Friday, now we have 8. We decided as a group to use Zoom as our video facilitator, and we adopted procedures for evidentiary hearings and certain and trials and certain more complicated matters. We also adopted rules, and these were adopted by other courts around the country, to allow all exhibits to be uploaded electronically to our court docket, and also created procedures to allow remote testimony by witnesses. We also immediately adopted certain other orders that set forth more formally the procedures for telephone hearings, authorizing the use of electronic signatures by debtors on certain documents, such as their bankruptcy petitions, their statement of financial affairs and schedules, which are documents required of every debtor, corporate or individual, to be signed under penalty of perjury, and also affidavits. So instead of requiring a debtor to come into a lawyer's office, we are allowing certain procedures, which if you'd like to see the details, you can go on our court website and see those orders. And other courts around the country did that too. We also closed our courthouse to the public completely. So at the end of March, we decided that we would no longer allow physical access to our bankruptcy court. That is not the same in all the districts. We created a special email address for debtors to file documents who did not have lawyers. Now, I know, as everybody is saying, that not everybody has a computer, and that's true, but just about everybody in the United States has a cell phone. And we also have mail procedures and have allowed delayed deadlines. So all of these things were created to try to make things easier for parties. Now, have we had some challenges, especially with our video conferences? Sure. We have ambient noise. I know that in my I have one large case, which I always do by Zoom. And for some reason, my neighbor's lawn person always cuts the grass right outside my home office window just when those hearings start. We have children that walk into camera shots and lots of pets. But, you know, you have to be flexible. These things happen. On the national front, Congress fairly quickly, certainly for this Congress, adopted the CARES Act, which is the Coronavirus Aid, Relief, and Economic Security Act. That was actually the second act that was adopted. But in sum, that act provided $1,200 per taxpayer with an annual income of $75,000 or less, and then with reduced amounts up to $99,000. Provided $600 a week in unemployment benefits for people who lost their jobs due to COVID, either because their business closed or because they had to care for someone who had COVID. But that expired on July 31st. The president signed an executive order for benefits for $400 a week when Congress failed to act. But that has been challenged because it's not clear that the president has the ability to enter that kind of a law. The CARES Act also created the Paycheck Protection Program, PPP. These are loans that, if used properly, do not need to be repaid. That is primarily for payroll and then also for rent or mortgage interest and utilities. The idea being that if the money was provided to businesses, they would continue to employ their personnel, even with the slowdown. If the debt does have to be repaid, there's a 1% fixed rate, and it must be repaid within 2 years. That process is administered by the Small Business Association and Small Business Administration. There was a big kerfuffle because the SBA was only allowing non-debtors to apply for those loans. Several suits were filed in bankruptcy courts around the country. I would say that the win-loss for the SBA is about 50-50, but the SBA has been working with businesses to try to get things resolved. Now, the next thing that we have was certain bailouts, an increase in a threshold for small business debtors under the Small Business Recovery Act, which was a law that just went into effect in February of 2020. And that debt limit was $2.7 million. That's been raised to $7.5 million, but only for 1 year, and allows bankruptcy plans, those are contracts for repayment, in consumer restructuring cases under Chapter 13, to be extended from the maximum allowed of 5 years to 7 years, but that's only for cases that were filed before March 27th. There were further attempts at relief in subsequent proposed legislation, but our Congress has not been able to stop fighting long enough to pass any more laws. Locally, most states have imposed moratoriums on residential evictions and foreclosures. Going back for a minute to the Small Business Recovery Act, it creates an easier business reorganization for small businesses and individuals with non-contingent, liquidated, secured, and unsecured debt, of which at least 50% was based on commercial or business activities. It's a much faster process. The debtor must file a plan within 90 days. There's a required status conference within 60 days. And the debtor must file a report 14 days before that status conference. A trustee is appointed in every case, but that trustee serves really as a business advisor or as a facilitator between the debtor and the creditors, or just as a reality check. No committee is appointed, and there's no disclosure statement unless the court orders otherwise. Disclosure statement, I always explain to people, the plan is the contract and the disclosure statement is the backstory. So no expense associated with the backstory. So what is happening now? A lot of big companies have filed. I'm sure many of you have read about it in the newspapers. JCPenney, Neiman Marcus, J. Crew, oil and gas companies, many different companies. But believe it or not, case filings right now have dropped in all the districts. But as Judge Hidveji had stated, it's like a wave, it's like a tsunami. So we're at the wave is going out, but we're about to get hit with a 30-foot wave that's going to drown us all. But will it? We're going to be ready. Many businesses are going to shut down. They're not going to be able to reorganize. As the prior speakers have said, this has just gone on so long that there's some that are just not going to be able to survive. The eviction foreclosure moratoriums will end, but the bankruptcy courts will be ready. We'll be ready technologically. I mean, we're all ready now, and we've been functioning, as I said. Manpower, well, case filings had gone down and we've cut our staff, but we are working both at local and national levels to do what we can to be ready at the time that it hits with our back office. As far as judges, we'll be ready as well. There's no such thing as temporary judges. There are some law professors that wrote letters to Congress saying that temporary judges should be appointed. We don't have such a thing in the United States, but we do have retired judges, recall judges, judges who recently retired who still remember the bankruptcy code, who might be willing to come back and help, and we've started reaching out to them. We also have some funding to provide temporary law clerks to those courts who need it. Of course, we can't determine what courts need it yet, because we don't know where the big filings will hit, other than the Southern District of New York, the Eastern District of New York, Delaware, of course, Texas. But we will be ready. Will this cause permanent changes to the way we operate? As Judge Fellows was saying, yes, there's going to be some changes. First of all, I think that we will be more liberal coming back with the use of video. As a matter of fact, right now, my IT team is working on a way to make it possible to have a video conferencing. Again, right now we're using Zoom while live court is being conducted, so that people remotely can participate with the local attorneys and parties in the courtroom post-COVID. I think we will continue to allow electronic signatures to some extent. And I think we will continue to allow the uploading of exhibits on the dockets to cut down on paper. So in sum, the world is changing. There's no question about it. I don't know how long it will be before we recover, and I don't think that we will recover to a world that looks like it did it before. I know the world that my granddaughters will grow up in will be very different than the world that I grew up in. Not that I mean, there were cars and planes when I was little. I want to make that clear right now. But in terms of the way that we communicate and interact with one another. But we're going to be ready. The bankruptcy courts will be ready. And I look forward to seeing you all. And whether it's by video conference or otherwise, as Judge Danielle said, I have a lot of bankruptcies from Brazil. And unfortunately, I think I'll have to see a few more. So thank you very much to iWork Brazil and everyone for giving me this honor and opportunity.
Thank you. Thank you very much, Judge Isaacoff. Here in Brazil, I think we are facing the same challenges in terms of courts work. We've been closed for 3 months. So we had to go to online work, 100% online work very quickly, switch the key from in-site work to online work. And I think we did very well. Judges are very used to working online now. Now we are reopening our courts step by step. We are allowing now in-site work, but not everybody is there. Not every judge is in court. Many judges are still working on home office, as we used to say. And let's see what happens when we come back to the normal life. I guess, as it will be a new normal life, somehow different than it is now. But thank you very much for your inputs. We love it. Thank you very much. Thank you. And now I'll have 10 minutes to give you an overview about the Brazilian responses. on the COVID-19 crisis. So, vou agora então mudar do inglês para o português.
So I will now switch from English to Portuguese.
Falar um pouquinho depois de ter ouvido essas grandes palestras, esses grandes comentários super relevantes e super importantes acerca de como diversos países importantes e relevantes no mundo responderam à crise do Covid-19. Né? Então, nós percebemos que Canadá, Reino Unido, Estados Unidos, Colômbia, todos caminharam no sentido de dar respostas para os problemas trazidos pela economia, pela pandemia, no funcionamento da economia. Eu sempre costumo utilizar uma observação que foi feita por um economista norte-americano, professor em Harvard, o Lawrence Summers. Ele diz que a pandemia causa um descompasso entre o relógio econômico e o relógio financeiro das empresas. As empresas perdem faturamento em razão das medidas de distanciamento social, medidas de lockdown, como implementadas em todos esses países, mas elas ainda têm que pagar as suas contas, as suas obrigações continuam. E é esse descompasso que gera uma grande onda de inadimplência, e essa inadimplência pode levar ao desaparecimento das empresas e pode levar a uma judicialização excessiva, a uma onda de ações judiciais que poderá inundar o poder judiciário e afogar os juízes no trabalho que venha num volume absolutamente inviável de ser respondido em tempo hábil. E aqui no Brasil, nós tivemos até agora 3 grandes respostas à crise da pandemia. A primeira resposta foi uma resposta governamental. Ora, se as empresas perdem faturamento e passam a ter dificuldade de cumprir as suas obrigações, o governo então criou linhas de financiamento especiais para ajudar as empresas a fazerem o pagamento de suas obrigações. Não obstante a boa vontade do governo em fazer isso, os números mostram, e o próprio Ministério da Economia reconhece, apenas uma pequena parte desses valores foram efetivamente emprestados, especialmente para pequenas e microempresas. Ou seja, houve uma dificuldade muito grande de fazer com que este crédito chegasse na ponta para as pequenas empresas, que são a grande maioria das empresas brasileiras. Uma outra iniciativa governamental muito relevante foi a criação do auxílio emergencial para as pessoas, que ficou conhecido no Brasil como Corona Voucher. Esse Corona Voucher, que é um pagamento em dinheiro de R$600 por família, beneficiou 80 milhões de pessoas no Brasil. E isso foi uma iniciativa governamental extremamente relevante, que num período de pandemia, onde o mundo sofre as consequências do empobrecimento da população, aqui no Brasil, esse auxílio emergencial acabou diminuindo a miséria no país. Agora, a grande questão é até quando será possível manter esse auxílio, como bem colocou a Judge Teisakoff. Uma hora esse auxílio não vai poder ser pago, e como é que nós vamos lidar com isso? Então, paralelamente a essas iniciativas governamentais, nós temos iniciativas legislativas. Existem basicamente 2 projetos de lei que buscam trazer respostas para os problemas da pandemia. Um projeto emergencial de vigência temporária, que é o PL 1397, projeto de lei 1397, foi aprovado na Câmara e aguarda a votação no Senado. E um outro projeto de lei, que é o 6229, que foi discutido hoje, enquanto nós estávamos aqui na nossa conferência, no nosso webinar. lá no Congresso Nacional, na Câmara dos Deputados, era fruto do debate sobre esse projeto 6229. Acabou não sendo votado hoje, ficou para outro dia, mas todas as discussões já foram feitas. E esses projetos, eles vêm no mesmo sentido da legislação inglesa. Por exemplo, eles buscam criar mecanismos de pré-insolvência que estimulem uma negociação prévia e fora do poder judiciário entre credores e devedores. Para isso, dando aos devedores uma proteção semelhante àquela que uma recuperação judicial dá, ou seja, uma suspensão de ações contra aquele devedor durante um período de negociação e a possibilidade ou estímulos, a criação de estímulos para que os acordos sejam feitos, seja através do financiamento DIP, do Debtor in Possession Financing, seja através da proteção e da vantagem a acordos realizados nesse período. E, por outro lado, buscam flexibilizar os procedimentos de recuperação judicial de empresas, ampliar o acesso de empresas a esses mecanismos e, da mesma maneira, dificultar a convolução em falência dessas empresas em razão da inadimplência nesse período, que não necessariamente indicaria uma inviabilidade da empresa, e sim um enfrentamento de uma situação absolutamente excepcional. Então temos a iniciativa governamental, as iniciativas legislativas, e aqui, infelizmente, eu entendo que nós estamos atrasados, já vimos que, tanto nos Estados Unidos quanto na Colômbia, quanto no Canadá, quanto no Reino Unido, Colombia and Canada and the UK, we have already seen legislative changes
Aqui nós estamos ainda
tentando essa implementação. E, por fim, iniciativas administrativas. Aqui no Brasil, nós temos uma autoridade central de coordenação e de fiscalização do funcionamento das cortes, que se chama Conselho Nacional de Justiça. Eu, inclusive, muito embora seja juiz titular de falências e recuperação de empresas aqui em São Paulo, nesses últimos 2 anos estive trabalhando no Conselho Nacional de Justiça e tive a oportunidade de participar da elaboração de atos normativos, de regulamentações, de funcionamento da justiça para tentar aparelhar o poder judiciário com ferramentas mais efetivas para o enfrentamento da pandemia. Então, nós temos aí a recomendação 63, que orienta os juízes a como proceder, ou a melhor forma de proceder, de acordo com as melhores práticas, com empresas em crise durante o período de pandemia. Tivemos agora mais 2 recomendações aprovadas, uma delas que estimula a criação dos centros de conciliação pré-processual, antes. Conciliação deve acontecer antes daquele problema se tornar parece que piscou aqui, mas já voltou. Antes daquele problema se tornar um processo judicial, né? E um outro autorizando a realização, orientando, melhor dizendo, os administradores judiciais a como proceder durante esse período com a apresentação dos seus relatórios. Muito bem, então eu acho que essas eram as considerações que eu teria a fazer. Eu agradeço imensamente o iWork Brasil pelo convite para poder estar aqui nesse momento, nesse evento, nesse webinar, fazendo a mediação de profissionais que são referência em suas áreas de atuação. Fico muito feliz e muito orgulhoso de estar ao lado dessas mulheres, como eu disse no início, mulheres poderosas, mulheres com uma posição de muito destaque na profissão jurídica e nesse campo da insolvência empresarial. Muito obrigado por terem permitido que eu estivesse aqui, podendo aprender com vocês, e desde logo, e por fim, peço eventuais desculpas por algum erro, algum equívoco cometido durante a condução dos trabalhos, que certamente deve ser atribuído ao meu nervosismo de estar aqui num momento tão importante como esse, ao lado de profissionais que são referência na área de insolvência em seus países. Muito obrigado a todos, uma boa noite a todos, espero que possamos nos encontrar em breve.
Eu acho que não vai precisar, pera. Pode desligar a transmissão. Desliga a transmissão. Desliga a transmissão.